Good afternoon. Thank you for attending our second in our series of financial literacy. Today, we are actually going over a letter to my surviving spouse. We'll talk about that topic and we'll introduce ourselves here shortly. But we want to just take this time, an opportunity to share. We have our third in the series on August 9th, and it will actually cover financial management and privacy best practices. So we wanted to kind of share that information. In addition, we are planning on more in our series in the future. And when you get our survey at the end, if you have topics that you'd like to share, we welcome that information because we want to make them as applicable to our participants as possible. So our presenters today, I'm Susie Krause. I am a consulting shareholder here at Lutz. I've been here approximately 29 years. I'm in our client accounting services department and also help with a variety of things as it relates to financial, tax consulting, small business consulting, and family office. And I'll introduce Amanda and let her talk a little bit about herself.
Hi, I'm Amanda Forker. I'm an attorney at Baird Home, and I specialize in trust and estates, both planning and administration. I've been in practice for about 12 years, and I'm happy to be here at Lutz today with Susie to talk about a topic that I enjoy helping people become prepared for and love the opportunity to work with Lutz because I know it will always be a thoughtful process.
Topic today is one of our financial affairs and planning. And why do we do this? Well, we do this due to the fact that we know that when others are facing serious illness or the loss of a loved one, we don't want you to have to deal with a financial crisis also. And I think every one of us maybe knows someone or maybe even have been in it ourselves, where when you're experiencing that difficult life situation and have struggled with those unknowns, the better prepared you are, the more you know, the less that we have those unknowns. We're trying to minimize those unknowns from your perspective. Why start now? Well, the reason why you start now is we know it's a hard topic. It's never too early to do that from that perspective. As you generate that information and identify your desires, it helps you have control and have confidence so that you know that your life's wishes are being met from that perspective. A foundation or a base of knowledge can really help support you, not only in your life goals when you're doing some planning during lifetime, but knowing that you have safeguarded all the assets that you and your family have created over your lifetime for the future in that post-death type planning. Our information today is really geared to hope in our hopes of aiding and understanding some of this information and to help you facilitate some future decisions. A letter to a loved one. Why was this topic important? Well, this topic was important to us, in our opinion, is that we want today to really give you guys thoughts so that you can focus on discussions and conversations to develop an understanding of your own financial affairs and then planning for your wishes and philosophy for your loved ones in the future. As we go through the presentation today, the most important thing to remember is communication. So others know what their loved ones' wishes are. We're going to discuss the documents. So the documents are very important so that you have a general understanding. But if you have anything that you can take away today, it is that you have to have discussion of your desires and your wishes.
I love the topic that Lutz chose for this presentation because so often we think of estate planning as a checkbox item. Once you've completed a will, it's done, and it really is just a document that you put away. But the theme, the consideration given to conversations, given to understanding financial affairs, as Susie said, we'll talk about the documents, but really that understanding is what makes a difference in the process being overwhelming or less stressful for your loved ones that administer it. So
yeah, no, Amanda, as you've talked, it is a process, right? I mean, it's not a one and done. I know it's almost like a stair step. I know that I've gone through it in my own personal situation. You start with something maybe not as complex, but as you become more comfortable and confident, you add things, correct?
Yeah, I always talk about it as an evolution of an estate plan. The first one is good enough. It's what your wishes are and you want it. And then the more you have conversations, the more deeply you think about it, the more you understand it, the more you really get it to where you're confident in what you're doing and you can share and communicate those wishes with each other.
And it's your document.
Your document. And just is easier on everyone at the time to administer it if you feel comfortable and confident in it.
Very good. Letter to a loved one. What does that mean? Well, it's not a legal document, but what it really does is it enables people to actually share. It's a way of stating your desires and give your family confidence in what your thoughts and ideas were. It really is something you personalize. It can be long, it can be short, but things that we really would encourage you to include in there is points of contacts for questions, people who you believe are your trusted people of who you go to. Also, words of encouragement. Share with them memories. Give them words of advice on the instructions so that when they get to the point of having to what I would call invoke or administer the documents that we're going to talk about today, give them a little bit of, things that you wouldn't put in a legal document, something more in your own terms and your own words. But there's also, we've heard people do videos. So whatever you're comfortable with, if you'd rather do it in a video versus a written document, but it is really your document to share information with your loved
I think so often we think the process executes itself. You planned, now someone takes these steps. But what we forget is that estate administration occurs right after you've lost a loved one, and there's more to it than checking the boxes and administering that process. The more you've shared conversations ahead of time, the more you've left notes, words of encouragement, things for your family to follow that aren't necessarily a legal guideline can be really helpful and comforting in that process. So they were really thinking about understanding it, and then what goes beyond it, what makes it less stressful for those people involved in your life that you care about.
Very good. I know one of the things we really talk about is understanding wishes and philosophies. That letter may be one way of explaining something. Either you want to give them more information as to the why. Not that we ever want anybody to not share the why when people are able to have that two-way communication. But
sometimes it doesn't work that way. Each family is different and each family is unique. And for some people, it's during life that you should share it. And for some people, it's nice to share it after.
I mean, one of the things that, we talk about the importance of having conversations. There are some families who are very open and very dynamic and very willing to share anything and everything. And there are other families that may not be able to do that. Some reasons why, maybe.
So all families have different dynamics, and the decision for how you share information depends on your own personal family and what's best for those involved in your life. And there are times in everyone's life when it's maybe appropriate to share more information and times when it isn't, or sometimes there is a hard circumstance with one beneficiary or the other and you need to protect siblings relationships. There are a lot of complicated thoughts that go into when and how to share it, but having those conversations, considering when and how to share that information, means that whichever way you choose is going to be thoughtfully presented, and they will have a better understanding of why you made the plan that you did.
One of the things we always encourage, there are ideas that we can help generate as your advisors, that if you have those situations, those are the types of, you have the conversations with yourselves, but you also have them with the professional advisors so they can share ideas and examples.
Estate planning is not something people do very often. They do it once for their own family. They maybe help parents, have a few conversations about their friends, but the people that do it all the time and really get to experience what it looks like in a lot of different families and a lot of different circumstances can bring a lot of ideas to the conversation.
Very good. I know that some of us are very comfortable discussing finances and estate planning, both during lifetime and post, and others are not. We talked a little bit about making habits. Share with us some ideas of how we can make a habit.
Yeah. I think the habit that I would feel is important is revisiting the conversation, having that conversation, you and someone important in your life, whether that's your spouse, whether that's family at this point in time, but continue to make a habit of thinking about it and saying, this is the time when we're going to consider what we have here. Is this still appropriate for us? Has anything changed in our lives? Do we want to share anything differently? And just, it could be a date night. It could be a fun adventure where you know that is going to be a little bit of the conversation that you have. We understand that this is not necessarily everyone's favorite conversation, but that makes it easy not to have it. And so making a habit of saying, okay, we're just going to talk about this tonight and make sure that we understand we're both still comfortable, both have the knowledge we feel like we should have, and then keep going is the habit that I feel like is
And it's not something that somebody's just gonna bring up haphazardly. You have to schedule it. You have to, plan for it, because otherwise, if you don't, it just never comes up. We're all busy in our lives, right?
We don't necessarily choose this topic as a fun night, so the habit is important.
Absolutely. Let's schedule it.
So now we're going to talk a little bit more about how does it get started? What should you be thinking about doing? We talked about it being an evolution, so complete planning as soon as possible. We do think you want to have a plan in place. And in my experience, just getting that first plan in place is a step in itself because you've worked all the way through the process once you learn to understand the documents. So getting a plan that you feel comfortable enough with in place right away is an important step. Where do you store documents? Do you provide copies to others? So storing documents has changed a lot over time. They almost always used to be stored in a bank in a safe deposit box. At this point, most documents are accepted on a PDF basis. And so while you will store your originals in a safe place or keep them with your attorney, we usually tell you to have them accessible to someone that needs them, whether that's the desk drawer in your office at home or that's a kitchen drawer. Where would your family look for your important papers if they needed them? And having them there. You also do get the question as to, do you provide copies to others? And that is a question of your comfort level in sharing your planning at this point in time. Most of your planning is all revocable. You can change it. So the people that you have nominated in it or the disposition of assets that you have in it may change over time. And you want to feel comfortable that those people that have it can understand that aspect of the planning and make a decision as to whether you should give copies now or later, or give contact information for the person that has those copies when they need them.
It's a personal choice and kind of dependent upon where you're at in your own circumstances from that standpoint. From the perspective of, some families, as we alluded to earlier, have dynamics where very, very open and the children are all professionals and can handle it. But you brought up a very, very valid point that if I prepare my will or I do my life planning, now, I can change it. So if that causes consternation for someone that it's changed, may affect if they want to share those documents.
Yeah, and it's a good conversation to have with your advisor that knows you, that knows your family. What's the right decision for me in terms of when I should share the documents or whether I should provide contact information or how should I do this knowing my family and my situation.
Very good. We talked about complete planning as soon as possible. Is that kind of like something I can just one and done?
Some people can, most people can't. Most people complete it and go home and keep thinking about it and hopefully have that annual conversation, and it continues to get more detailed, more individualized, more tailored to your specific instances. So there are those unusual circumstances where one is enough, but it's helpful to keep thinking about it. And probably if you keep thinking about it, you'll come up with something that you want to make sure you've covered in your plan.
I know that when I did it the first time, more in depth now that I'm older, but it was a document was prepared and then kind of idea generation things to give consideration to. Sent me home and my husband and we talked about it and then kind of highlighted some things, came back, met with the attorney again. Similar situation, almost back and forth, maybe 3 times before we actually got to those final documents, correct?
Right. Yeah, there's probably a minimum of 3 meetings in designing that initial plan. And that's really time for you to think about and understand and come back with questions and make sure there's nothing that you want to change or update. And that's just the first iteration of it. There are also clearly stages in life. We're younger, we're focused on guardian for our children, things that need to be taken care of at that stage. And as it progresses, the plans tend to get more detailed, more complex, take a little bit more time and attention moving forward.
Important to know, it just isn't something I can, if I'm leaving for Italy tomorrow, that you just can't whip out tonight.
Very occasionally we can. It's very, very occasional that we do that.
Understand. A couple other things as we talk about, how we can be prepared. Providing account login credentials is key and important. Everything between electronic banking and email and so much we talked about a little bit before when we were preparing for this. So much now is in electronic format that it's not paper. It used to be that you could direct your loved ones to go to paper. Now we really probably need access to email. So in our next session in August, they're definitely going to talk about that login information, how we can protect it, but how you can access it for those loved ones also. Creating a checklist. One of the things that Amanda and I have prepared and compiled is a conversation checklist for you and your loved ones. Definitely things to give thought to. Due to time constraints, we're not actually going to go through that checklist today, but when we send out the PowerPoint and we send out information later on, we'll have a couple other takeaways. We'll share that checklist just to help generate conversation with your advisors.
Make the habit of having the conversation.
That's right. Take that to date night. Last but not least, inventory of assets is so important. It takes into account things, not only income producing property, but non-income producing property. Income producing assets and things you own are probably easier to trace by using your tax return or some financial data, bank accounts, those types of things. Definitely important, extremely important, but non-income producing assets are also important. And I know that's something that we encourage people to use their advisors to start right away. Do a very good, thorough listing to start with. And then as you think about it, you're going through this process, you can continue to add. I know you brought up a couple different things like sentimental value items or vacation homes. Maybe just share a little bit about importance of those, what I'll call more unique assets.
Yes, about planning. We need to know what we're planning for. And it's easy to think we all could list off what we own immediately, but it's harder than it seems when you get into it and think about making sure that that list is complete. That list is financial assets, checking accounts, brokerage accounts, insurance policies, all sorts of assets that could be ones you don't pay attention to on a daily basis. Are there stock certificates in a safe deposit box? Getting an idea of everything that's there will be really helpful to someone that helps you, one, understand what you have and make that plan, and two, administers an estate plan. The things that we see that take additional thought because they don't divide as easily are personal items and second homes, vacation homes, things that your children may have an attachment to, things that people have more questions about: who gets them and why, and how did you handle them the way you did. Interestingly, money that divides evenly or assets that can be converted to money don't cause as many questions as assets that are unique to your family, your history, the things that have become values to your children.
Things like if we're used to going to the cabin for 4th of July, who gets it?
Yeah, right. So there are some things that, while they may not jump out at you as the most important asset in your portfolio, actually take significant time and thought for us.
They can create the most strife and discussion.
They can. And that's where those shared conversations about values are important with your children. If you have assets that you think people are going to have questions about how you're going to handle, or what's the best way to do that, or why did you make the decision that you made? And that could be you telling them during life. It could be you telling them in a letter. But generally, children handle a decision that their parents made, and they understand why better than a decision that they're left to all determine why they think it might have been made or suspect it might have been made. Direct communication on those sentimental items is important.
Preparedness.
Preparedness.
Once again, things that, if you start that list, if you don't know where to get started, I know we gave the checklist in our initial presentation, good starting point, but also important to reach out to your accountant if you need a personal financial statement to get started, those types of things. So very good. All right. Couple things as it relates to professional advantages, things that are important. There are things out there that are what we'll call a CAN document, like a LegalZoom, and you can go out and just do it. And sometimes those are applicable and helpful. But what we really want to talk about is the reason why, even if you have a very simple estate and you want to use a CAN document, that sometimes can create more difficulty in administration if it's not tailored to you. So we really believe in the use of customized documents. So someone's asking these questions. We are really high level today. We're not even getting into what I call the meats and potatoes, because it's just time doesn't allow us to. But we know that if you're using CAN documents, you may be missing some important topics, important things to give thought to. Also understanding those documents, correct? One of the things Amanda and I talked about as we were preparing for this presentation was, we've seen people write a hand document quickly because I'm leaving tomorrow or something of that nature. Or, hey, I want to change my document. I don't want to have to go back through my professional advisor. I crossed through it. But you shared something very important with me, that if I had crossed through one of my legal documents, what happened?
Yeah, we'll only read the handwritten portion of it, it becomes a handwritten document at that point in time. So you do need to make sure that you go through the formalities of execution of a will anytime you want to make a change. We all understand that sometimes we think about it at a strange time and we remember that, but you can send off an email, get that document updated properly.
Very good. Just something that came up, I want to make sure we shared. Talk to us about safeguarding, how that happens.
Yeah. Safeguarding is really preparation of yourself for the process and knowing that you've asked enough questions to understand where the financial assets are, what the plan is, and who's going to help you at that point in time. And as I've practiced, I have seen time and again that those people that have a developed team of trusted advisors that know them, that know their assets, that know their families, that administration side is so much smoother because they have trust and they have people that already have all of their information put together. I've already said it, but it's a hard time. When you're administering an estate, it's a hard time for everyone involved. It's a hard conversation. Having those people that do it on a regular basis that are already familiar with you makes a really big difference. And I'll be the first to acknowledge that people don't love to spend time with their advisors that charge by the hour, but it really does come down to efficiency for the people you're doing it for, which is the beneficiaries of your plan, and it goes faster, it goes smoother. That trust that you have built and that knowledge that they've gained over the amount of time that you've worked together is really important.
It's important to share that all this preparation isn't, if I'm the one doing the preparing, isn't for me, correct?
Right.
It's really for those that I'm leaving.
An estate plan is really a gift for the people that are administering that plan down the road and the people you care about and the people that you want to make this easier on.
Absolutely. I know that there's so much, I call it legalese, so I don't mean that disrespectfully, but there's so much legalese to documents. So understanding them, going through them, reading them, some of that legalese has to be in there because of regulations, right? But you can really help break it down. Your advisors can help break it down so we really can understand it and execute it from that standpoint. Taking advantage of things like these, meetings like these are helpful to help you educate from that standpoint. One thing to take away today is continue to communicate, develop confidence in your documents, and customize them to you. Next, there are some people that are participating that really would like to receive credit, continuing education credit. So at this point in time, we're really going to just do a CPE poll. So we are going to take 1 minute to have you answer this question, just so that you can get that CPE. And if you need CPE, please email Reagan, and her email address is on the screen. We'll be right back. Welcome back. We did have one question that we wanted to address. We are going to address questions periodically throughout if there are several, but the majority of the questions we'll take at the end as a Q&A just to make sure we get through the material. But please feel free to share questions as you encounter them. And we may address them immediately or we may address them at the end during the Q&A. The question that arose was, how do you start that inventory list? Is there something that we can do to start off? You know what, there are some ideas that we can share. We are going to send no later than Friday, a few takeaways, some things that we're going to walk through here in the next couple slides, as well as that conversation list that we talked about earlier. We can actually share also, how do you start an inventory list? We'll share some of that information because the mission today is to really help prepare you guys for conversation. All good ideas that we can share from that standpoint. Amanda, how do we start?
So you're right. We're talking about understanding today. And one of the things that's hardest to understand is that this is legalese. There's a number of forms. There's a number of categories. It takes time to become familiar with it. You have to revisit, what are these documents we're talking about? What does each one of them do? who have I named and what have I asked them to do? And so continuing to refamiliarize yourself with the unfortunate legalese mixed in with how do these documents function? Why do I have them? And in my mind, there are two categories of documents that people have. They have lifetime documents and they have post-death documents. And that's the beginning breaking point for me of where I start to think about separating them. Lifetime planning documents are powers of attorney. Lifetime planning documents are things that people will use to assist you if needed while you're alive. And so there are two forms of powers of attorney that we talk about when we talk about estate planning. Powers of attorney are almost always encompassed in a conversation of estate planning because they are planning for someone to help you in the event that you become unable to do certain things. We're going to talk about the two forms of powers of attorney today, one of which is a financial, generally called a general durable power of attorney. The other is a medical. It is a healthcare power of attorney, a living will, an advance directive. And that is, again, one of the places where this becomes hard. Each state, each advisor may refer to that healthcare power a little bit differently. So we'll talk about what it does so that you can recognize, even though it may have a different name, if it's nominating someone to help you with healthcare matters, it's going to be in this category of a healthcare power of attorney. And the reasons for those names are because different states' laws called the documents different things when they enacted them, and it has crossed over. So you will see them called a number of different things.
You know, you shared, as we talked about this, there might be a couple things that are just standard, but these are just more for information sharing purposes. But if you don't mind, maybe pulling up the financial power of attorney, we're just going to show a very standard one and maybe have you just kind of walk through a few things.
Most states have a prescribed power of attorney form that's available on the state website. That's going to be your most basic form of power of attorney for both financial and healthcare matters. For this conversation, we pulled up the Nebraska State General Durable Power of Attorney and Healthcare Power of Attorney to talk about and look at. When you think about these two functions, you're naming a person and at least one successor person to act on your behalf in the event that you're unable to do so. For finances, you're naming someone that can help pay your bills, who can contact the utility companies, who can file your tax return. You're naming the person that will help your everyday financial affairs continue to run in the event that you can't do so. When you look at this state form, sort of on the bottom of your screen of what you're seeing, it has check the box. I give these powers to my agent. These are quite general. They're described more specifically in the state's laws, but then if you look at more specific forms developed by your advisors, they will include things like, do I want to allow the person I have asked to serve in this capacity to gift to my family? Should that gifting be limited in any way? Am I going to let this person change my beneficiary designations? And should that be limited in any way? So while these are available in a really general form, depending on your circumstances, the complexity of your assets, there's certainly more conversation to be had about
In your
the
wish
power
list,
you
right?
need to give.
If I wanted to allow some, but not other,
Yeah.
these are very, very broad and general.
Yeah.
Whereas if you develop your own, it can be very specific.
Yeah.
And it can be invoked at different points in time, correct?
It can. So one of the specific areas that we've seen come up when people look at these after they're acting is, can I continue the person's charitable gifting? And so that's a thing very specific to people. Is this important to me or is it not? And did I authorize it in my power of attorney? And then the second piece of it is, when is it invoked? You can draft a power of attorney in two different ways. You can draft it as presently effective or contingently effective. And if it's presently effective at the time you sign it, the person you need will be able to act on your behalf. If it's contingently effective, the person you've named would have to prove your incapacity in order to act on your behalf. That's a conversation that warrants some consideration and thinking through. Usually as to spouses, we're okay. Just, I don't want you to have to go through the burden of proving I'm incapacitated. Please just step in and help. Sometimes when it's not a spouse, you do want the protection of they can't act while I'm capable to act, and I'd like to have it contingent upon my incapacity. And so you may format that document in a couple of different ways, depending on who you're appointing and what your comfort level is with control of your finances.
Can I have more than one person named, or do you do co, or do you do alternates?
We do. So all of this comes back to the personalities and the ability to work together of the people that you appoint. You can name as many people as you want. You can name that they have to act together, or that any one of the people named can act individually if you think that Those people you're naming would divide and conquer some of the tasks. You can give them the ability to do that. You do have to think about whether they can act together. And another question we get often is, can they be out of state? Do they have to be here? Do I need to name somebody here in order to do that? I think is we're all realizing it's a lot easier to be anywhere in the world and take care of things than it used to be. And so most of the time, their location is not a hindrance to their ability to serve this function anymore.
I know this is a very canned document, and we're really just sharing this so that people can see there's some very broad spectrum to it. But really, you really want to tailor this to your own situation. And how do I go about the best process of selecting what authority I give someone in this power of attorney?
Legalese. So a big part of that is having an advisor that you've gotten comfortable with, that knows you and can understand these are the types of things that are going to be important to my assets, my family, my plan, and they can help you review the powers that can go in there and select which ones you want.
So my assets will help make a determination. Probably my family situation will help make a determination. So definitely something that you need to have conversations with your own family, but then also with your advisors.
Combination of both in order to get the right powers for you. And then if we talk for just a minute about the healthcare power of attorney.
So this was actually a financial. So
This is
there's
a financial,
two, right? There's a
there's two.
financial power of attorney
Yes,
and a healthcare power of attorney.
this is the healthcare power of attorney. The healthcare power of attorney concept encompasses who has the right to direct your care in the event that you can't. It can cover who has access to your healthcare information, and it also tends to cover what type of care you'd like to receive in end of life state. So all three of those are important components. Who do you want to give access to your healthcare information so that they can understand what issues you may be having at that point in time? Who do you want to be able to communicate your wishes for you in the event that it's difficult for you to communicate that one person? Again, is that multiple people? Are they local? Are they non-local? What's important to you, and who's available to do that? And then,
I mean, we like to see everybody agree, but sometimes that can be a burden if there's an emergency type situation. Is that correct?
it can be. It also can be hard for certain individuals, even if you want people to agree. Using healthcare power is hard. You have to give hard instructions for a loved one, and some people are more ready to make that instruction than others. And so it's important to consider, can they agree, and is this a function they're comfortable doing? And this is one that it's important to communicate to the person that you're asking to make these decisions for you, and make sure they understand what your wishes are in each of these instances.
Can I change these powers of attorney at any point in time if I'm still of sound mind?
Anytime you want.
Okay.
Powers of attorney can be changed anytime. The alternative to powers of attorney is a court-appointed conservator and guardian. So for people that have not already named the person that they want to make decisions for them, if they become unable to make decisions or manage their financial affairs, the court has a process by which they would name a conservator or guardian to serve these functions for an individual. The powers of attorney are a lot easier to use than needing to go through the court.
When do you typically see this being as a challenge or causing strife or causing problems?
It can be a challenge, particularly as it relates to healthcare, if people disagree as to the appropriate path. We see it occasionally when we have a second spouse and we have children from a prior marriage, and they disagree upon living arrangements, they disagree upon proper care, and it's really where communication becomes important. If that person can communicate what they want to happen ahead of time.
So if I'm going to name someone, I want to have those conversations of advanced directives and living will and life support and those types of things. This is where it's really important to have hard conversations.
Important to have hard conversations. People can understand it much better coming from the individual making the request than they can coming from.
Easier to
someone else.
enforce than if you're the one left making the decision.
That was a brief conversation about lifetime planning, powers of attorney, and we are going to also talk about post-death planning and what those documents look like. And this conversation is really to continue to build familiarity with what the documents are and what you're thinking about when you're looking at each document so that you feel comfortable with them. Not everyone will have each of these documents when it comes to post-death planning. They're documents that you might consider, you might talk about, and you might want a general understanding of. So a will is the traditional way to dispose of assets. And I might give more in-depth background on some of these if we have questions, but do we want to run through
let's just
each of the documents?
Absolutely. There's the three that we have up here that we can kind of talk about. And I know that you're actually going to maybe kind of show a flow chart of how this maybe at a very, very high level flies. But I know a will actually directs the disposition of my assets. And in today's world, there's really more complex situations that a will goes through probate, and probate means that anybody and everybody can see your assets. Is that a fair statement?
It is.
So a lot of times what you have seen, especially of those people with significant assets or wealth or things that they maybe want to protect, are using other documents to what I would call collaborate with their will. And so those are types of things like the revocable trust and the irrevocable trust. And both of those documents bring into situations opportunities that can protect, can keep confidential, can give more direction, can be invoked during lifetime, correct? From that standpoint. So maybe even just sharing what each one of those documents do, and then maybe going into a flow chart. We've shared a couple things up there from that perspective. Revocable trust means it can be changed, right? Irrevocable means it can't be changed from that perspective. But maybe just real high level talk to us a little bit about how the three interact.
Absolutely. So we talked a lot about estate plans being individual to you, individual to what you need. And I told Susie that it does happen that I get phone calls and they say, we were out to dinner and my friend said they had this type of irrevocable trust. Do I need that? So I don't have expectations that it's always dinner conversation, but it is important for you to feel comfortable that you know your plan is tailored to you and you know what each document does. So the will, as Susie explained, provides where your property goes. In the event that you don't have a revocable trust, it will name who those actual beneficiaries are. If you do have a revocable trust, it becomes what people refer to as a pour over will. And so you'll hear the term pour over will, which says I give all the assets in my will to my revocable trust. And then the revocable trust will actually name who the beneficiaries are of your property and what they get.
Real quick, revocable versus irrevocable. Many people may know this, but just in case not, difference.
Revocable versus irrevocable. When you create an irrevocable trust, you are transferring property to it that you can't get back.
So I'm done.
Okay.
Once I put it in there, I have no options of changing it.
That property is not available to personally support you. There are a lot of complex types of irrevocable trusts where people do some extra planning. Those are beyond today's conversation, but we want you to know that they're out there and you can ask additional questions about them. But the basic difference between a revocable trust and an irrevocable trust is a revocable trust really functions like a will. Everything you put in there is still yours. Creditors can still reach it. You can still use it to support you and you can change it anytime you want. An irrevocable trust is a more complex planning technique where you really are parting with the assets that you put in there at the time you do that.
Helps with estate planning as well as transfer of wealth. You know, most commonly we see things like life insurance trusts, irrevocable trusts, those types of things.
Yes, so there are a number of estate planning, estate tax considerations where people do create irrevocable trusts for that purpose. And the common ones are irrevocable life insurance trusts. Spousal lifetime access trusts have become common in the last few years. But
kind of complex. That's why your professional advisors in your own current situation can help you determine, you know, what should be in revocable and what should be in irrevocable and what can we do from that standpoint. Is it fluid?
it is. The estate planning tax situation is fluid. People's assets are fluid. The ages and stages of their children change on whether they want to give gifts out right now, whether they want to use trust to manage property. Estate planning really is a fluid process throughout people's lifetime that continues to change as they do. And our goal is really that when you hear revocable trust, when you hear irrevocable trust, you feel like you have a good base as to what direction your advisors are talking about, what your friends are talking about. Why are we talking about a revocable and irrevocable trust?
And do you do one or the other? Are they collaborative?
Not necessarily. Some people may have one or the other. Some people may have both. Some people may have multiple types of irrevocable trust. Some people may have two revocable trusts. Sometimes we'll create two revocable trusts if we're monitoring separate property and marital property. So there are different ways that you can use each of those types of trusts that are unique to your own situation.
So this is really the example of a CAN document versus really working to make it customized to your situation, because some people have family businesses and others don't. So it might come into that play. I know, Amanda, you kind of put together a flow chart at a very, very high level that we can maybe walk through.
Yeah. So when we talk about estate planning and we talk about wills and we talk about trust, sometimes I think of assets in buckets because assets pass by different mechanisms. So one of those mechanisms is the will that we just talked about. They can give it directly to individuals, and you'll see a will in green in the middle of this flow chart. Another is a revocable trust. You can use a revocable trust to own your assets and pass those assets under the terms of that trust to beneficiaries. That's another bucket. There are also buckets outside of the typical estate planning document context because they're joint accounts. Joint accounts automatically pass to the other owner named on the account. Those don't flow through what you've specified in your will or what you've specified in your revocable trust. So it's important to think about the ownership of those accounts and how that impacts the disposition, whether that's consistent with what you're seeking to have happen or not. Another bucket is transfers by beneficiary designation. So both qualified accounts, tax advantaged accounts, IRAs, 401ks, and life insurance pass by the specific beneficiary designation that you send in to the company that manages the policy or the plan. And so for many of us that set up our retirement accounts or bought our insurance policies a long time ago, we filled out our primary and contingent and we set them in never to really be thought of again. And it's important when you think about your buckets of assets and managing your estate plan that you revisit the actual titling and beneficiary designation on assets that may have existed for a long time to make sure those are going to go where you really do want them to go.
The will might not, the will or the trust that we create can't address those because they're addressed separately.
Right. They're addressed separately unless you make your designation to have them flow through your trust. And that has its own conversations, especially as it relates to tax advantaged accounts. It's really important to learn that there are different mechanisms. It's not just one will. There's joint accounts, there's beneficiary designations, there's a will, there's a trust, and becoming familiar with how each of these would impact the flow of your assets.
And they're collaborative.
They are.
They can be as long as you set them up collaboratively.
As long as you set them up collaboratively. And no one is expecting that 1 hour would make you learn all of the names on these documents or how they work or what they hold. But the more you think about them and the more you talk about them, the more you have that date night to say, what's in our revocable trust? The more you'll feel like you understand it.
That repetition is important just to gain comfort, right? And you learn a little bit more every time you talk about them. None of us start off understanding all of this information. It takes time, energy, repetition. Plus thought. You think about something and then you add more as you give thought to it and encounter different things. Very good. So there are different roles and responsibilities that come into play when you're administering your wishes, both during your lifetime and post-lifetime, correct? We just wanted to talk a little bit high level what these are so people are familiar with the documents or familiar with the terms. So personal representative or an executor is someone that is typically named in your will to help you actually just manage the estate, correct? It gives them the power to do the inventory. You know, we talked about inventory before, but if you start the inventory, sure helps. But inventory all your assets as well as your liabilities. They pay your bills. They're responsible to oversee and protect your wishes that are named in that will. That person is your personal representative or executor. They can be a beneficiary of the will or the trust also, correct? Power of attorney, that is one of those things during your lifetime that you actually identify someone. Talk to us a little bit about a power of attorney.
So when we think about roles and responsibilities in a power of attorney, you're thinking about who can help me during my lifetime. When we talk about roles and responsibilities in that personal representative or trustee, we're talking about who's going to help execute my wishes after my death. And we get a lot of questions about how do you pick the right person for these roles? Should you pick more than one person? It's important to categorize and understand what you're asking each person to do. And when I think about estate plans from a very high level, I think about the who and the what. So who are you asking to be involved and what are you asking them to do? And so this is the who, the roles and responsibilities. You're asking certain people as your powers of attorney to act for you during life. You're asking certain other people as personal representatives and trustees, which could be the same, but they could be different, to help after death to administer your wishes. And in choosing those people, you're thinking about their dynamics with your family, their trust with your family, their skill set and capabilities in administering a financial process, their knowledge of healthcare, having a conversation about who the individuals are that could potentially serve in those roles, and then identifying a succession of people that could fill them.
It really comes back to communication. Sometimes it's important to let these people know they have these roles, correct? Because I mean, you want someone that's trustworthy, that can be assertive when they need to be, that they're responsible. But you also want someone that's willing to take that role on, that can advocate for your desires and wishes, correct?
You are. It's nice when we can tell people that this is what they're going to be asked to do and they can understand that. There are occasionally circumstances where it's not the right time to tell people. And the other thing that you can do is you can make sure you've named a succession of people. And I've had clients say to me, we think our daughter would be great at this, but we recognize that she's busy. And so we've actually written in, it's okay if you want to resign and turn it to the next person in line. So you can give them permission to make the decision of whether it's appropriate in their life. And again, that's not a legal concept. That's you telling them, we're confident you could do this, but we also understand if this isn't the right time for you to take on that burden, and thinking about who could serve in successive roles there.
And coming back to communication from that standpoint. So some things from the standpoint of estate planning, we've talked about a lot, but we wanted to just kind of maybe walk through a little bit of high level considerations. Things like, we talked about preparing the documents. We've talked about the different documents, everything from the will, an irrevocable trust and a revocable trust. So those things we've discussed, but talk to us a little bit about managing the estate tax, because that's important, correct?
It is. We have not taken a significant dive into estate tax consequences in this conversation, but it is something that will be important with your advisors. Once you've determined what your inventory of assets is, you can begin to gain an understanding of the estate tax laws. Those laws have been complex over the last 10 years. They've changed a number of times. There have been proposals that weren't enacted. So it's been an active time in monitoring the estate tax laws. Currently, federal estate tax is paid after a person transfers more than $12.92 million during their lifetime and at death. And so when you think about that, that includes lifetime gifts, and then it includes what you transfer upon your passing. It's important to continue to be aware of what's happening in the estate tax law area, and your advisors will be able to have that conversation with you and be able to plan appropriately for your own assets. And
it's a combination of things, right? It's annual gifts, because there's an annual gift tax, or excuse me, annual exclusion amount. There's lifetime gifts if you maybe want to do things before it starts to what I call appreciate in value. Those types of things are all important to make sure we're giving thought to. You know, we talked next about, we have listed up here a little bit about titling of assets and your debts, and then update. I know a lot of people will do this kind of a one and done type of situation. We've seen that occur. And one of the things that I guess we really want to make sure is if you walk away today with nothing more than a high level of knowledge, the second thing we want you to walk away with is it's fluid. They need to revisit it. They need to do it more frequently than once your children are born and once your children are of age, correct?
Correct. Monitoring your assets is really important. It's very easy when you gain a new asset to just put a name on it and think it's okay and not think about it again. We find a lot of LLC interests or things of that nature that just have one name on them. They don't have both spouses, or they don't have a trust because it was convenient and it was perfectly fine at the time that it was done. But if you don't come back and revisit your assets, then that does become a little bit more difficult in administration.
I mean, really making a good list of your assets is an important starting point. I mean, you start your job so you identify who your beneficiary is, and maybe you never go back and change it, correct?
Or you have a marital change. We encounter circumstances where people have beneficiaries designated that are former spouses. So there are life events that cause you to need to update and revisit your beneficiary designations.
And by having those conversations and sitting down and actually giving thought to it, you can determine that list of assets and even debt, so that you make sure you know what you have going on. Talk to us about, I know we were talking more about Nebraska when we were pulling up the powers of attorney. Different rules for different states?
Different rules for different states. States generally recognize the existence of documents that were signed validly in another state, but tax laws are different. The way that the tax characteristics of your property changes upon death may be different based upon what state you live in. It is important to at least revisit and have the conversation and confirm that everything is still appropriate to your situation if you change your residence. And for many people that we work with, that simply means they start spending 180 plus days in a different state of the year. They may still have a residence in both states, but if your residence changes, you also need to consider whether your estate planning documents need to change.
How often should I be meeting with my professional advisors to update some of my information?
Well, they love to see you, but it would be good to talk to them at least once a year, even if it's a quick conversation. The more your advisors know, the more they can see and pick out something that will be helpful to you. We all get busy. We all have times where it's hard to do that, but ideally you would talk to your advisors at least once a year and get a full list of everything put together.
Very good. We want to just summarize high level. I know we've covered what I'd call at a high level, a lot of different topics. And I know as we plan some of these meetings in the future, we probably will dive deeper and you're going to get a survey of other topics that might be of interest to you. Please take these into consideration. But if you have some takeaways today, one, have some of those tough conversations and plan before events occur while everybody is of sound mind, body, and togetherness. Identify areas that you feel maybe you need more information. Reach out to your professional advisors. Ask some of those types of things. If we hit upon something today that doesn't make sense to you, write it down. Ask the question. Consult your attorney and your tax advisor. They really do have a lot of information available to you from that standpoint. You know, some of the first time conversations, and I'm sure you could probably chime in here too, is, you know what, where are my accounts? Where are things at? Make that account list. Who do I contact first? You know, if something does happen, do I have a general understanding of the process? Those are the types of things that your professional advisors can definitely help you.
The extent that you can go to the meetings. I mean, we all sort of divide and conquer responsibilities because we're busy and we don't have time, but just that hour of sitting, if one of you is going to go, then both of you go and listen. The more frequently you hear it, the more you're going to understand it, the more it's going to bring up conversations and questions. And I'm probably guilty here, but it definitely is helpful the more meetings that you can go to.
Very good. I know that we have some few minutes left. We wanted to see if there are further questions so that we can address those questions. But while we're looking at those questions from that standpoint, you will be receiving a survey right after this, right after you leave Zoom. Please help us complete that survey, share topics, share informations. We've referenced a couple different documents today that we are actually going to send out sometime in the next couple days. We like to share what we call takeaways or items that you can kind of lean on from that standpoint. So take those as items of education, ask us questions after you receive them if you have it from that standpoint. But we definitely want to take a look here at some questions from that standpoint, answer those questions. Do you have a suggested inventory list you could share with us to help us remember? Yeah, we definitely have what I call a high level starting point from an inventory standpoint that we can definitely share in those takeaways from that standpoint. But more than anything, you know, you can start with your tax return. You can, you know, more often than not, you alluded to it earlier, it's not necessarily all the monetary things that, you know, you've decided you're going to split evenly or a third or however you're going to split them. It's those sentimental assets. How have you maybe helped some people prepare for those maybe things that aren't on the tax return?
It takes time to identify what's important to your family. And I think when that question gets asked to you the first time, it's hard to know. But as you start to have someone say, okay, well, what things do you have in your house? What personal property or collectibles or vehicles that might be important to your family do you see? As you start to watch your family interact going forward, then we start to see people more. They hear it when someone says, oh, I really like that painting. You start to notice more people's inclination towards what might be important and how that is to address within your family, and whether
and family dynamics probably plays a role, right?
Yes.
Some families are very open and they're going to put their names on the back of it, and other families,
which is not a legal directive, but it works for many
Yeah.
people. And so some families can just go 1, 2, 3, 4, 4, 3, 2, 1, and they can split everything up without any disagreement, without anybody asking what anything's worth. Others want to know what's worth $2 and what's worth $5,000 and want a price on everything. And so the more conversation that you can have about how you want that to look for your family and whether you need to specify any of how that will happen is helpful. And I think it really does develop over time once you start thinking about that conversation.
first step is really just having the conversation and giving it thought. And it, like you said, it'll evolve with time as you get more comfortable.
It will.
Very
Well.
good. Second question, do you need to change beneficiaries listed if someone gets married and the name is changed?
You always should update them frequently, and it's your own individual circumstance. Most beneficiary designations also require a social security number. They require a decent amount of information, and they're going to be able to identify that person. But if you recognize that your beneficiary designation is out of date, I would go ahead and update it. Most companies at this point, you can update it online. If you log into your account online, they have a beneficiary designation section, and it's pretty smooth to update it. Some you can still send a paper in and fill that out, but if you know that it's out of date, it would be great to update it.
I mean, things that come to mind on those, and we talked about them earlier in our conversation, is when you start your job and you have life insurance, or you know, you do it once and you forget about it because it's not even coming to mind. Definitely things that you need to sit down and give thought to.
Right. A lot of people have an employer provided policy or something that they're not really monitoring on a regular basis, and they kind of don't think about being out there, and they filled it out when they started. And so
Same thing with your 401k or some of your
Mhm.
retirement. Definitely things that you want to make sure you're tracking.
yeah, if you know it's out of date, go ahead and try to update it.
Next question, can you have more than one executor or personal representative?
You can. You want to think about how the dynamic works on whether they agree, how many need to agree in order to act, and whether or not naming more than one person is going to be helpful for the job that needs to be done.
And can you
Based
name,
on
you can probably
personalities.
name more than one person and they can either act independently or have to act code. It's probably dependent upon family dynamics. Is that fair?
It is. It is dependent on family dynamics and how they will do that.
Sometimes it's very fluid and you want them to be able to execute what they need to execute quickly. And other times you know that you want to avoid conflict.
Yes.
So it
And
just depends.
if you think that conflict is a possibility and you have two, you want to address deadlock. You want to say, okay, I'm appointing these two people, but
Maybe you need three.
this is the person that gets appointed if they can't agree, or
Yeah,
this is the person that
person's gonna have more weight.
that does make that decision in the end. And so there are a lot of things to consider when you decide whether you appoint one or more people to serve as an executor.
Understand. Does Nebraska law require that the spouse be named as the executor or person representative of the will?
You can choose to name the personal representative or executor of your will if you draft and prepare a properly executed will. If you do not have a will, they do have a priority right to serve as your personal representative. And so making that will allows you to make that selection. There are laws as to what you have to leave a spouse if you don't have a pre-marriage agreement in Nebraska, but not as to appointment to serve.
And different states have different rules. Is that correct? And you alluded to it earlier that, you know, hey, you may have written your real will originally when you were a resident of the state of Nebraska. And now maybe you live in Arizona, or maybe you now live in Florida. Definitely something to give consideration.
It is. And I've looked at plenty of plans where I said, it's fine. You know, thanks for letting us look at it. You're now a Nebraska resident. Until something changes that causes you to need to update it, this will be recognized and it's fine here. So asking the question and asking for a review doesn't necessarily mean you're going to have to redraft your documents. If they function properly the way that you want them to, they can stay in place. But getting that professional opinion of, yes, everything is in place and transferred fine to my new place of residence is helpful.
Question, does having beneficiary assignments and transfer on death assignments, such as, you know, on your financial account, your vehicle titles, property titles, does that override probate and the will?
If you have transfer on death assignments and financial accounts, vehicle, property titles, anything that you have it on will pass outside of probate. It will
And it's
pass outside of
important
your
on
will.
titling that, right? I
Mhm.
mean, the way you title that's important. Is
The
that
way you
correct?
title that is important. It will go to the person you name on it. And so we do see people that name one person on all of their assets with the intent that they think their kids will just split it out. Sometimes that works perfectly well and fine. Sometimes for one of the kids, there are tax consequences that are unanticipated if you're asking them to gift assets that technically they received to their siblings. And sometimes someone decides they're going to keep it all. So you do have to think about, if I'm naming beneficiaries in order to avoid the probate process, is it going to end up being dispersed in the way that I want it to be dispersed, depending on how you put them on there.
But it's better probably at least, I mean, hey, you want to give everybody the benefit of the doubt, but to avoid what I'd call hard feelings or anything, spend the time, energy, and effort to get things in line, titled correctly, identified correctly in your will and your trust. I know that. Go ahead.
As a follow-up, we do have an inheritance tax return in Nebraska right now. And so it does have to be reported to the state. Everybody does see a copy of who gets what in the process of preparing that inheritance tax return and signing off on it. So it doesn't fully avoid the administrative piece of it to use transfer on death designations or joint ownership.
I know one of the things that I always tell people when I'm dealing with it, the first thing to start with is start with your inventory. Identify who you want to have what. Just sitting down with your spouse or your significant others or your family members and walking through what's happening is a very valid starting point. Talk to us about what you think is a starting point and what we should do. I know we only have about a minute left, but
if you're having trouble starting it, I would encourage you just to go see an advisor and have them facilitate the conversation. It can feel like homework. It can feel like I have to fill out this spreadsheet. That's great and it brings organization to it. But if that's hard for you to start, go in and just sit down and let someone ask you the questions and put it together for you, because it is a really hard process to get started, to find the time. Sometimes a calendar appointment finds the time. Sometimes someone who knows and can ask all the follow-up questions finds the time. I think it's personal. Some people can sit down and fill out their spreadsheet and be done. And some people need to just set an appointment and go in and say, we're going to do it together.
if I know I'm not going to have a taxable estate, is it still important for me?
Still important for your family. The more organized it is, the smoother the process is going to be. The more your wishes are going to be carried out if you have it in process.
We are about out of time. I want to say thank you to Amanda for sharing all your knowledge and information. We are available for questions if you have them. We do have another session scheduled in August, so watch for that future event coming on board. And as you get the survey, if you have other topics, we want to make this applicable to people so that we can educate. So please share. We're staying high level right now, but our hope in the future is to maybe become a little bit more detailed, share a little bit more in depth after we've had the opportunity to be high level knowledge information. So thank you all for attending. We look forward to your comments after you receive the survey. It will be being sent out right after this. And then we have some takeaways that we're going to share with you in the next couple days. If you have questions, please don't hesitate to reach out. Thank you again and have a great afternoon.